Welcome to my YouTube channel. It's good to have you here, and welcome to the Law Speaks. It's a classic Kelechi quiz series. On this channel, we'll discuss uh, legally related topics, and we x-ray issues, and we try to expand on them. So feel free to drop your comments or contributions on the topic we discuss as we ride along. It will be so much appreciated. So without further ado, we'll cut straight to the chase. I have with me here a colleague by name CK Anyanwu. Welcome to the show.
Thank you, sir.
Yes. Today we are going to be talking about an accused, the presence of an accused in a scene of a crime. Whether the mere presence of an accused in a scene of a crime amounts to commission of the offense. So we are going to be x-raying it and other principles that fall under it. We're going to be talking about the parties to an offense. We're going to be talking about proof beyond reasonable doubt to establish conviction in an offense. So we are going to be going the full length. That is why we have CK here to help us as we carry on with it. So CK, who is an accused? Your own understanding. We are talking about the presence of an accused and the scene of a crime. Who is this accused? How do we identify or understand who an accused person is?
Yes, thank you for this opportunity. Yes, for purpose of definition of who an accused person is, I will borrow a leaf from the Black Law Dictionary 6th edition. The Black Law Dictionary 6th edition defined an accused person as someone who is arraigned in court and who is facing a criminal trial over a specific offense or offenses. Thank you very much.
Yes, and we can also say, from what you rightly pointed out, that anyone that has been arrested or formally charged to court with an offense or a crime is an accused person. Exactly. Okay. Then, before a crime is established in court, there must be parties to that crime or offense. By parties we mean, the person that obviously has been charged with the offense, as we have rightly identified as an accused. We can also mean, a person that might have witnessed the offense or a person that might have reported the offense either to the authorities or to the police. So we can term them complainants. We have complainants, in a criminal offense. So can you shed more light on parties to an offense?
Okay. Now, when we talk about parties to an offense, we mean those that have contributed one way or the other in the actual commission of the offense. It takes us to Section 7, Section 8, Section 9 of the Criminal Code Law, the Federation of Nigeria. Yes, Section 7 specifically talks about the commission, parties who contributed one way or the other in the commission of the same offense. Now, this Section 7 has subsections. It has subsections. It has subsection A, it has subsection B, it has subsection C, and it has subsection D. I will take each of these subsections in ad seriatim. Ad seriatim, I mean, is that I will take them one after the other. Section 7A of the Criminal Code Law of the Federation of Nigeria talks about the person who actually committed the offense. Take for instance, if I pick up a gun and shoot you now, no doubt about it, I personally committed the offence.
Sure.
Yes, that takes care of Section 7A of the Criminal Code Law of Nigeria. Going forward, Section 7B talks about the act or an omission. An act or an omission. Having explained Section 7A who actually committed, then Section 7B talks about, it has two limbs. The act, if you do an act or if you fail to do an act, that is an omission. Yes. Now, Section 7B talks about the act or the omission. If a person does an act or fails to do an act by way of an omission which leads to the commission of an offence, that particular person is said to have also committed the offence. In the same vein, Section 7C talks about who aids. The underlying word here is aids. Aids. In English, in the literary meaning, it means an assistance. But in the legal connotation, we use the word aid, particularly with respect to the subject matter. Now, Section 7C talks about where a person aids another person in committing an offence. That particular person who aids, who assisted, may not have committed the offence, but will be seen also as a party that have committed that offence. Take for instance, if I return from work and maybe my wife did not cook, even though I'm not yet married, and my wife did not cook, maybe I became pissed. Then I eventually tell someone who is in the house to please help me with a particular thing. And when that object is being given to me and I strike my wife, that particular person who assisted me with that object, which I strike on my wife for failure to cook at home, will also be said to have taken part in the actual commission of an offence. Now, going forward, I will not go into Section 7D. Section 7D deals on procurement. Who procures? Who counsels? Yes, we use the word procurement as a legal terminology. Section 7D talks about when a particular person procures or counsels another towards the commission of an offence. Take for instance, if a father advises a son, informs him on how to go and stay in another person's house, the father will be said to have procured, to have counseled his son towards the commission of an offence, and the father will be deemed also as a party to the same commission of the offence. Now, having explained the purpose or the import of Section 7 of the Criminal Code, permit me once again to delve into Section 8. Section 8 talks about common intention. Common intention. Common intention has to do with where two or more persons forms this common intention to commit an offence. Where two or more persons forms a common intention to commit an offence, it goes that long way to say that they have indeed committed that offence, and each and every one of them will be said to have taken part in the actual commission of the offence. And again, we talk about Section 9. Section 9 now gave an elaborate explanation of Section 7D, which talks about the procurement or counseling. Where a person procures or counsels another person towards the commission of an offence, that particular person is said to have also taken part in the commission of an offence. Now, I wouldn't stop it at this juncture. I will also look at the parties to a criminal proceedings. Parties to a criminal proceedings is quite distinct from the parties to an offence. Having exhausted the position of parties to an offence, now I will also, in a nutshell, discuss parties to a criminal proceedings. There is this erroneous conception, even amongst our colleagues, that the nominal complainant who initiates a criminal matter through the police before it gets to a court is a party to an offence. No, a nominal complainant, having initiated a criminal matter either by way of petition, yes, or oral complaint, yes, at the police station, is a party to an offence. But the moment that matter at the police station goes to court, the nominal complainant ceases to be a party to an offence. At that juncture, the state takes over.
The commission of police.
Thank you. Yes. At the commission of police.
Yes.
That nominal complainant is no longer a party, but rather he is not a vital witness for the prosecution.
Yes.
So, with regards to parties to a criminal proceedings, we now look at the accused. who was the suspect at the police station, who is facing a criminal charge in the court. We look at the accused, we look at either the commissioner of police or the state. These are the only parties to a criminal proceeding. So I would also use this medium to throw more lights, to not just the viewers, not just to the laymen, but to our colleagues that nominal complainants are not parties to a criminal proceedings, and let them stop the idea of the nominal complainant is not in court, that he's not serious about the matter.
It does not hinder the case.
It doesn't cease.
Yes.
It doesn't stop a court from hearing a criminal proceedings, even if the nominal complainant is not in court. Thank you very much, sir.
Yes. All right. So that was very, very good and expansive. I believe we have learned. I'm learning a lot. I'm learning a lot from this. Now, we have already established that that nominal complainant or a complainant is someone that either reported to the police or has alleged that someone committed a crime or an offence. That's a nominal complainant, and he's not a party to the offence. Instead, he's a vital witness to the offence committed whenever the proceeding comes to whenever it comes to court as a criminal proceeding. He's a vital witness for the for the prosecution. So it's good that came out. I believe we are learning. Let us have it in mind. If you have any contribution, please don't fail to go to the comment section and put your own contribution across. We need to know your opinion. No one here is an island of knowledge. Now, I just want to comment on the area of procurement and counsel that you talked about, also aiding and abetting. This is for those of us that give people wrong suggestions or advice. Even as lawyers, you're advising your clients. I've been involved in a case where the opposing lawyer actually advised his client, kill him, cut his head. Once you cut his head, once you kill him, the case is over. As a lawyer, how can a lawyer be giving such advice? The implication of that advice is if your client takes your advice, follows it through. Of course, you as a lawyer that gave the advice, you did not use the machete or the knife or the gun, or you not even pull the trigger, but you advise someone to do it. You are also culpable. Whatever consequence that arises from such action of the person of the accused, that consequence if you also fall back on you. So we should put it into cognizance that you aided or abetted means that you are also part of the offence. In fact, you are a major part of the offence. So moving on, CK. Must an accused person be present at the scene of crime? Must he be present at the scene of crime to prove commission or prosecution to prove that he actually committed that crime? Must he be present at the scene of crime? We are getting to the rudiment of our discussion.
Yes, thank you for this fundamental question. Yes, an accused person must not be present at the scene of the crime before the said accused would be seen to have committed an offence. If during the criminal prosecution, during hearing of the criminal matter, if the prosecution will be able to establish an evidence linking an inference linking the accused person towards the commission of the crime, the accused person will say to also have contributed towards the commission of the crime. So his presence there, he must not be present before he will be said to have taken part in the commission of the crime.
Okay. So when will the presence of an accused person, when will the presence of that accused person at the scene of the crime amounts to his actual participation in the crime? Yes. When exactly?
Yes.
His presence.
Yes.
Scene.
The presence of the accused person, an accused will be said to have taken part, or maybe to have one way or the other contributed towards the commission of an crime when he or she participated in the commission of the crime. That is when that particular ingredient suffice. When he or she participated. Take for instance, maybe you came to our office and maybe you wanted to borrow the law report, Do you understand me? Now we have rules and regulations, we have ethics that guides our office with respect to borrowing of law reports. We don't deter lawyers from borrowing, but before a lawyer borrows a law report, we must record your name, the particular part you are borrowing, the date you borrowed it, and we also have a column where when you return it, we will sign you out or sign you up as having returned it. But whereby I know of this precedents and I know of these rules that guide from our office, and then you come to our office to borrow this law report, and I did not follow that part. You understand me? I have also contributed. You understand me? Even that is it.
So how about a co-accused? We talk about, when you talk about co-accused, talk about their conspiracy. How about a co-accused? Is the presence of a co-accused at the scene of a crime actually relevant in determining, that the co-accused actually committed the crime? We are talking about aiding and abetting.
Yes.
Talking about conspiracy.
Yes. I rightly defined the position of law with respect to parties to an offence. The issue of presence of an accused person, that of the co-accused, cannot be rightly spelled out without making reference to parties to an offence. Now, take for instance, we have 5 persons met and agreed to commit an offence. After their discussion, which have established conspiracy, then 3 or 4 out of that 5 proceeded and committed the offence, leaving 1 person behind. Now, for the fact that that particular person did not take part in the actual commission of the offence does not mean that he did not commit the offence. Now, by virtue of conspiracy, which is a distinct offence, which joins the number of persons that committed the offence together before we now go into the particular offence that was committed, by virtue of conspiracy, that particular person, that 1 person left behind, have also taken part in the commission of the offence. Thank you, sir.
So finally, sir, we know that one of the major ingredients, in fact, the third principle in criminal proceeding is proof beyond reasonable doubt. I think it's tried that it is better that 99 criminals go scot-free than 1 person. So because of that, it is so stringent, and it's difficult. Sometimes it's difficult for the prosecution to actually get convictions. That's why we see a lot of criminal cases. Whenever it's determined one way or the other, you see that the prosecution always loses out. So on this proof beyond reasonable doubt, how can the prosecution actually get a good case? What does the prosecution need to do to be able to get this conviction? We are not trying to say that it's necessary that the prosecution must get a conviction, but for the sake of justice, you see a lot of people that are culpable, in an offence. You see a lot of them going scot-free. So what, in your years of practice, I know you have been a defense counsel and you are used to actually securing discharge, securing acquittal. How can the prosecution, because we know all these things, the lapses of the prosecution, and you bank on those lapses to get your judgments in your favor. What do you think that this prosecution they are not doing, that they need to do better, in order to foster criminal justice? Yes.
Okay, this is a very Herculean task towards me at this juncture, because with respect to my colleagues on the other side, that is private legal practitioners, whose duties predominantly is to defend these accused persons in court, I seek their kind permission to throw more light to the prosecution. He's a prosecutor. He's my very good friend, my senior. He's a prosecutor and he does well in the court. I usually do my very best in research each time I'm to face him in court. Now, going back to the task ahead, yes, criminal prosecution starts from the police station, and having initiated a criminal matter at the police station, either by way of oral complaint or by way of petition, Now, an IPO, an investigating police officer, takes position by way of investigating the crime. The law is well established right from the police station, because where the right of one stops, the right of another person begins. Now, there are some principles of law that takes place at the police station that is very fundamental in hearing of that criminal matter, which the IPOs at the police station does not really take care of very well. Take for instance, the Administration of Criminal Justice Law, Act, the Administration of Criminal Justice Act provides that an accused person must be recorded in the presence of his lawyer. In the presence of his lawyer. Failure to record the statement of an accused person in the presence of his lawyer negatives that particular statement of the accused person who is the suspect at the police station. And again, another vital point to be made at this juncture is the police investigation report. I have done matters where the police, particularly the investigation reports, did a porous investigation. Take for instance, there was this matter, a criminal matter I did at the magistrate court in 2019. The police having furnished us, the prosecutor having furnished us with the proof of evidence needed for us to prepare our defense. I studied it, and during the course of studying it, I realized that the investigation report was incomplete. The investigation report was incomplete. And in this regard, it's suffice to say that there was no investigation. And failure of the investigation report to either recommend for the charging of that matter to court or not affects the duties of the prosecutor in court. And at this stage, the prosecutor cannot perform magic. The prosecutor cannot withdraw that investigation report because already it is before the court and it is also in the possession of the defense counsel. So these are part of the things that leads to criminals going scot-free in the court. So in summary, I would suggest that there should be a continuing legal education, not just towards the lawyers, but to the police. The Attorney General should start a continuing legal education towards the police station in an area of sensitizing them on how to go about all these things. A lot of police officers are not well acquainted on how to carry out police investigation. And more importantly, the newly recruited are not also well trained. So you can see that it affects the duties of the prosecutor in court. So the idea of continuing legal education should not only be for lawyers, it should also be for the police, because in criminal justice system, the police, the lawyers, and the courts are the three fundamental institutions when it comes to criminal justice system in Nigeria. Thank you very much, sir.
Yes. So just to add to what you said, CK, in a criminal trial, the best form of evidence that is available to the prosecution to prove their case and to, at most, get a conviction is, confessional statement, and not just confessional statement, voluntary confessional statement, not statement gotten by force. So if you can't get a voluntary confessional statement, it's not bad. The next best evidence is that of an eyewitness, a credible eyewitness.
Direct evidence.
An eyewitness, credible eyewitness with a credible testimony that fixes the accused at the scene of the crime, and not just fixing the accused at the scene of the crime, also detailing the active role that the accused played in the commission of the crime. Now, once that is gotten, any court that is not biased will actually do justice. So that being said, I believe that in this discourse we had, seek, I believe that there are plethora of authorities. Plethora of authorities, we mean case law authorities and citations inclusive. But for want of time, we might not be able to detail them here. But if you go to the comment section, we'll try to put those authorities out there so that we can evaluate for ourselves and also see for ourselves. So that being said, we have come to the end of this discourse. So grateful to you, CK, for finding time to come here.
My senior.
I believe
Thank
that
you very much. Yes, I'm deeply humbled.
I am humbled as well.
Thank you, sir.
Thank you for coming for coming on the show. I believe we will have more of you. Please, if you like what we did here, if you appreciate what we did here, just do us a favor of liking the video. Drop your comments, your contributions, your opinions. Also, subscribe to the channel so that we'll grow, so that we can do more of this. Then share to your family, share to your friends, share to everyone so that this channel can grow. We trust that you've had a good viewing, and we'll see you on the next one. Thank you so much. Please remember to like, share, subscribe. Thank you very much once again.
Thank you. Bye bye.